Please, Your Lordship, I beg to mention item number 3. This is those matters when the company is required to file their audit report for a particular year, but they're still pending, Lordship, before the regional director's office for compounding of the same. And also, Your Lordship, in this matter, the conducting counsel is Mr. P. Nongbri. He's still in bereavement. So I'm praying, Your Lordship, if the matter can come up after 6 weeks so that we can seek instruction on the status of the compounding proceedings before the regional director's office.
Miss Counsel for the petitioner has sought for accommodation on the ground that the conducting counsel, Mr. P. Nongbri, is in bereavement. On premium list, we'll give 4 weeks.
6 weeks, Your Lordship.
Enough time have been given in this matter.
Your Lordship.
From time to time, either
Your
2
Lordship.
weeks, 3 weeks, 4 weeks.
Your Lordship.
It's never ending. I don't know why.
Whatever falls from Your Lordship.
We'll see as as and when
Your Lordship.
the period comes, then we'll see.
Oblige, Your Lordship.
Kuruntua. On premium, this is matter after 4 weeks.
Your Lordship, similar prayer for item number 4 and 5. There are similar issues, Your Lordship,
Yes,
regarding,
they are
yes, sir, the money
same
for
order.
Amrit. Yes, Lordship. Highly obliged, Your Lordship.
Supplementary list, item number 1.
Yes.
I have this statement. Ms. P. Bhattacharjee.
Donation allowed. Only
Lordship.
for admission.
I believe the miss case that is listed today is for stay. There's another miss case listed today, my lord. MC 12 of 25.
End of the board.
Gotcha.
From daily list, item number 1.
So this matter is attacked together with item
Yes,
2.
Lordship.
So
With
item
item
2 is to be
two.
taken. 2 is to be taken first.
Lordship, they are supposed to file, the government is supposed to file a affidavit, counter affidavit.
Or
Yes, Your Lordship.
it-
Item number 2, yes, Your Lordship.
That is
We're
for item
requiring
number 2.
some more time, Your Lordship, to file our affidavit, Your Lordship.
sure, shouldn't take so much time.
We've not received complete instructions, Your Lordship.
Have you filed yours?
No, they are supposed to file first. If necessary, we will file later. If necessary,
Why file first?
because Lordship, we are lately mid party to this case, Lordship.
Yes, yes.
First of all, regarding whether the proceedings has lapsed or not. So in regard to it, they are filing the counter to it, Lordship. So nothing to say in this regard. Let them file whether lapsed or not.
I don't see any logic there.
Yes, Your Lordship.
Point being,
No,
you have been arraigned as party respondent. Maybe you see at a later point of time or earlier point of time makes no difference. The fact is, as of now,
Lordship,
you are a party.
if it is lapsed, Lordship, we have nothing to say in this regard, Lordship. So as per opinion, it has not lapsed. So let them state so whether lapsed or not, Lordship. As on the last date, they were supposed to file. They prayed for filing the counter to it. 2 weeks? 1 week?
2 weeks.
How long?
2 weeks, Your Lordship, may be given.
Miss Ailuma G has sought for accommodation on behalf of the state respondent as far as filing of the counter affidavit is concerned, which could not be filed today. It is prayed that some more time will be allowed for the same to be filed. Prayer law. Mr. Learned Counsel has appeared on behalf of the respondent number 5. Dr. N. Musica, Learned Senior Counsel, is present on behalf of the petitioner. As prayed for, this is matter after 2 weeks.
Lordship, I hope
So as far as number 1 is concerned,
Yes, Your Lordship.
Lordship.
as far as item number 1 is concerned, then
Yes, Your Lordship.
you should list this matter after 2 weeks.
So can this a large chance may be given? Make it 3 weeks also.
He's a
Make it
respondent,
3
Your
weeks also.
Lordship. He's a respondent in this case.
I simply
How
make
can
it 3
you
weeks.
such
I hope
a-
they file after 3 weeks also.
You should make an endeavor to file.
Yes, we will file, Your
Otherwise, unnecessary.
Lordship, can I take that date on?
You suggest a date then.
Yeah, on 15, 16. After 3 weeks also, okay. 25. Instead of 2 weeks, you're getting 3 weeks.
So 15,
16.
16. How to get this is matter to who? As agreed to by the parties, this is matter on 16.
Much obliged, Lordship. Item number 6.
My lord, this matter was previously heard, my lord, a couple of weeks back. My lord. This matter pertains to, my lord, non-consideration for promotion, my lord. In the year 2013 onwards, the petitioner was not considered for promotion and he was superseded. My lord, I have placed the facts, but I will again place the facts subsequently, but not today, my lord. Today I am only on the point of, my lord, the objection which is raised by the state, which concerns them is the finance part, my lord, the back wages. Whether he is entitled to back wages or no, if he is notionally promoted, my lord. So on that point, my lord,
No, but how wouldn't that be, taking up the matter, in the middle portion, so to say?
yes, my lord. But what I'm seeking for today is, my lord, some time to obtain instructions from my client whether he would like to forfeit the back wages portion, my lord. If he is granted, assuming he is granted notional promotion, my lord, then he will not ask for back wages. He will not. I will advise him that.
Back wages, principle of no work, no pay.
My lord, my lord. But still, I'll have to, my lord, obtain instructions from him whether he would like to press that or no, my lord. Because, my lord, what happens is, my lord, he is already retired. Now, if he does not press for back wages, then the only thing that is left is, my lord, for fixation of pay, my lord. As on the date he is notionally promoted, the pay will have to be fixed, my lord, and the subsequent promotions till his retirement, then his last pay will differ, my lord, will increase. So his pension will accordingly be fixed according to that, but without pressing for any areas. So I'll just obtain instructions on that, my lord. I'll come back.
That you see, it's not necessary for you to seek instruction on that. Once the matter is decided on merits,
My lord.
that could be, you see, if it's up to you,
Yes,
it could be an additional point of contention, whether you would like to raise it or not.
Yes, my lord. My lord.
So,
My lord, my instructions is whether I should press for it or no, my lord. Because it's a huge amount, my lord. So if I won't press, if I'm instructed not to press for it, I'll make a statement that I'm not seeking for any back wages. That way, he will not have any claim in future, my lord.
so Mr. No, if I can understand correctly, it's not a question of pressing for it or not. It is a question of, in the, the
Whether he's entitled or
in a
not.
complete scheme of things, whether you are entitled to or not. If not, matter ends there.
Yes, my lord.
If you are entitled to, then.
No,
Because you have to, like you said, you have to cross the first hurdle,
yes, my lord.
whether you are entitled to,
Yes, my lord.
at this point of time, notional promotion or not.
Correct, my lord.
Whether
Because,
the
my
rules
lord,
provide for it.
if I won't, if I do not press on the back wages, then your lordships need not decide on that point. So your lordships will only decide on notional promotion and the subsequent benefits without back wages. That will be the only point. If at all I'm entitled.
You can advance your argument now as far as the other part is concerned, as far as notional promotion is concerned.
Yes, my lord.
And then perhaps some other day we'll go into the other aspect of the matter.
My lord, then I'll just place the matter from the beginning, my lord. because it's been more than a month now. Judgments.
Any other, okay, private respondents are no longer there.
Yes, they've been struck off because during pendency of the writ petition,
Yes.
the petitioner has since retired. Therefore, nobody will be affected. My lord.
But
Yes, my lord.
nobody will be affected. But I'm still to understand. See, I'm not so proficient in service law.
My lord.
What would the gradation list?
It will not affect anymore.
Let's put it this way: the rippling effect that it would have. So whether it'll jolt somebody from their position or not.
My lord, since I'm retired, so physically I will not be joining office. So it will not affect the gradation list. And moreover, my lord, many have retired and some of them have my lord, since passed. So my lord, physically there won't be any effect. It is only on notional promotion. So my lord, in 2013...
You have to elaborate on this.
Yes, my lord.
On the issue of what is notional promotion,
My
how
lord.
it is affected.
My lord.
How would it it affect the person concerned or the government for the matter?
Lord, I'll just take your lordships to page 15, annexure 1. This is, my lord, the appointment of the petitioner.
Page 15.
Page 15, annexure 1. This is dated 26th of October, 1988.
Yes.
So, my lord, why this notification dated 26th of October 1988? The petitioner was, my lord, appointed under 3F, my lord, of the Meghalaya Public Service Commission, my lord, Regulations 1972. So it was a 3F appointment, my lord, subject to exams. Yes, examination by the MPSC, my lord. Now your lordships will find at serial number 9 is the petitioner, my lord. Now, my lord, the name of the petitioner here is, my lord, NJD Booth. But he joined service as NJD Booth, but during his service, my lord, he changed his name to, your lordships kindly have the cause title. He's changed it to Shut Up, his original clan, my lord.
Okay.
So, my lord, in 1988, he was appointed under 3F. Subsequently, my lord, when the advertisement was issued by MPSC, my lord, at page 20, annexure 4, annexure 4, the petitioner sought for permission, my lord, to appear in the exams. Page 20, annexure 4.
Yes.
This is dated 9th of August 1989. So an application was made to the officer concerned, my lord, for no objection to appear in the exams. Then, my lord, pursuant to this no objection, the petitioner appeared in the exams, and the notification of appointment, your lordships will find at page 23, annexure 6. Page 23, annexure 6, my lord. This is the appointment letter, my lord,
Yes.
issued by the government in terms of the recommendation of the MPSC, my lord. It reads, my lord, in pursuance to recommendation of the Meghalaya Public Service Commission, the following persons are provisionally appointed temporarily and until further orders to the Meghalaya Agricultural Subordinate Service grade 1 in the scale of so and so, my lord.
Yes.
So, my lord, the petitioner, your lordships will find at page 25, serial number 11. Serial number 11, page 25.
Yes.
So serial number 11 is the petitioner, and the previously impleaded respondents were from serial number 12 onwards, previously.
Okay.
So the gradation list is prepared in terms of these merit list issued by the MPSC. So here we are concerned with this number 12 onwards. Now I'll take your lordships to the rules that governs the service of the petitioner. Now these rules came into effect when the petitioner joined service. These rules were not in place. It was during the service that these rules were formulated and notified. At page 31, Annexure 7. Page 31, Annexure 7. The rules were notified on 29th of October 1996. And these rules are called the Meghalaya Agriculture Service Rules of 1996.
Yes.
Composition of service, your lordships will find at Rule 4. Rule 4, which provides for composition of service. It reads, service shall consist of following grades: senior grade, grade 1, grade 2, grade 3.
Yes. It's not Rule 4.
Grade 3, Then thereafter, Rule 7 provides for recruitment, method of recruitment.
Yes.
So, at that point in time, when I was not considered for promotion, I was in the lowest grade, that is grade 3. Now, if your lordships kindly have sub rule 3 to rule 7, which provides for appointment to the post of grade 2.
Yes.
It reads, appointment to any post in the grade 2 shall be made by promotion from amongst the members of service belonging to grade 3 as specified in Schedule 2 and included in the select list approved under sub rule 4 of rule 9. So, rule 9 provides for the preparation of select list. So similarly, for climbing from grade 2 to grade 1 is provided under sub rule 2 of rule 7, and senior grade is provided under sub rule 1.
Yes.
But we are concerned here with sub rule 3. So rule 8 provides for departmental promotion committee. These are the members specified. Now the procedure for preparing the select list is provided under rule 9, which reads, sub rule 1 of rule 9 reads, at the beginning of each year, the appointing authority shall refer to the committee the approximate number of vacancies likely to occur in each cadre of the service during the year, to enable the committee to prepare the list. For promotion to those cadres, the appointing authority shall furnish the committee with the following documents, namely, number 1, a list of members of the service drawn up in order of seniority. So a list has to be drawn in order of seniority and consisting of 3 times the number of vacancies referred in sub rule 1. Now this is rule 1 to rule 9. Now rule 2, sub rule 2 to rule 9 provides for examination of the rolls. So it reads, the committee, after examining the character rolls, service records and other documents in respect of all persons, shall prepare a list based on seniority, with due regard to individual merit and suitability. The number of persons to be included in the select list shall be according to the actual number of vacancies. The list shall be forwarded to the committee by the committee to the appointing authority. Now sub-rule 3 is important, Bullet. The names of persons in the list shall be placed in order of preference for promotion. In each case where a junior member is selected in preference to his seniors, the committee shall record in writing the reasons for doing so. So this is my case, Milord. So Milord, the committee is the DPC, Milord, Departmental Promotion Committee. Now, when the departmental promotion committee, Milord, decides or prepares the list which is to be forwarded to the appointing authority, Milord, it has to be on the basis of merits or on seniority. Now, if any junior is promoted, recommended before any senior, my lord, reasons have to be recorded. That is my case here, my lord.
Are you privy to the proceedings of the DPC?
No, my lord. Neither that. In the affidavit filed by them also, my lord, nothing has been brought on record, my lord. Now, my lord, a gradation list pursuant to the rules being notified was prepared by the department, my lord, for all the posts, and your lordships will find at page 43 and extra 8. This is after the rules came into effect. Page 43 and extra 8, your lordships will find.
Type copy.
Typed copy, my lord, is the next page. After every page, I have placed the typed copy, my lord. Page 43 is the original copy. Page 44 is the typed copy, my lord.
This is a notice.
Yes, my lord. It reads, my lord, this is the 3rd of May 1997, after the rules came into effect. The Governor of Meghalaya is pleased to tentatively fix the inter se seniority of Meghalaya subordinate agricultural service officers. So, my lord, from page 45 onwards, your lordships will find the gradation list, my lord. And your lordships will find at page 72. Page 72 is the petitioner.
Page 72.
Page 72, serial number 102.
Yes.
So clearly, my lord, at serial number 102 is the petitioner, and serial number 103
Yes.
was a private respondent in this matter previously, my lord. So somebody who was junior to the petitioner but superseded, my lord.
Okay.
So just to point out, since we are here in this gradation list, my lord, petitioner was at 102, my lord. 103 onwards, my lord. 103 up to 122. And thereafter, in the second DPC, number 126 up to 138 had superseded the petitioner. I'm just pointing this out beforehand, my lord, since we are here in this gradation list. Now I'll just take your lordships to the promotion order of the juniors, my lord. Your lordships may kindly have page 85 and extra 9.
Yes.
Now, my lord, this notification is dated 10th of January 2013.
Yes.
Now, if your lordships kindly come to paragraph number 1, 2, 3, 4, 5, fifth paragraph, my lord.
Yes.
Which reads, my lord, in pursuance to the recommendation of the Departmental Promotion Committee, Shrimati Purnima K. Sangma. Now, Purnima K. Sangma was 103, my lord, below me in the gradation list. In this, Purnima K. Sangma, Agriculture Development Officer, is hereby promoted to the post of MAS 2, that is grade 2, my lord, of the Meghalaya Agriculture Service in the scale of so and so. So, my lord, this is serial number 103 in the gradation list, and the next one is also a junior, my lord, serial number 104. This Shrimati B.M. Umlong. I'll just check again from the gradation list, my lord. Yes, my lord. The next person, which is on the recommendation of DPC, is Shrimati B.M. Umlong. That person was at serial number 104 below the petitioner. Similarly, my lord, the other person, the next one, next, KB Lakyang. KB Lakyang was serial number 105. So, my lord, by this promotion order, my lord, serial number 103 up to 122, which were below me in the gradation list, were promoted, my lord.
Yes.
So, my lord, serial number 103 to 122 were promoted, and no reasoning was ever given, my lord, nor produced before this court why serial number 102, the petitioner, was not considered. While Rule 7 provides, my lord, sub Rule 3 of Rule 7, that when a junior supersedes or is recommended before a senior, reasoning has to be recorded, my lord. Nothing has been brought on record. Now, again in 2015 at page 91, your lordships,
So this promotion order is relevant.
yes, my lord. This is the relevant one, my lord, and even the subsequent one at page 91 is relevant. So I am seeking my notional promotion from 10th of January 2013.
What is this 91?
Yes, my lord. Page 91 is dated June 1st, 1st of June 2015. Now this is a promotion order of serial number 126 onwards, my lord.
Okay.
126 up to 138, my lord, in the gradation list below me, my lord. This happened in 2015. So, my lord, if I
126 serial number
126 to 131,
131.
and then 133 to 135, and 137 and 138.
All juniors too.
All juniors, my lord. So this happened in 2015, my lord. So my prayer is, my lord, if I'm notionally promoted from with effect from 10 January 2013, then it takes care of both the list, my lord. Now, pursuant to the promotion of these juniors, a gradation list was again prepared, my lord, by the department at page 94. Page 94, Annex 11.
Yes.
So, my lord, at page 97 onwards is the seniority list. Which shows, my lord, seniority list, my lord. Now I'll take your lordships to page 105. This is the higher post of MAS 2, where these juniors were promoted, my lord. This is related to them, my lord, as on 1st of January 2016, page 105.
Yes.
So, my lord, my junior just kindly give me a moment, my lord. My lord, kindly have page 111. 111.
Yes.
The last serial number 41. Your lordships will see that name, Purnima K. Sangma.
61.
61, my lord. Purnima K. Sangma. This was the person which is was below me in the gradation list. So her name and the rest onwards after that, my lord, from serial number 61, 62, 63, 64, 65, 71 up to 79 at page 113, page 114, 81 up to 88, page 115 up to 91. These were all my juniors, and they in 2016 their names are found in grade 2, MAS 2.
Yes.
Now kindly have the next page at
See,
100.
As on 2016,
2016.
they were in grade 2, you are still in grade 3.
Yes, they were promoted and I was not
And
promoted.
how is gradation list prepared? Is it grade wise or
Grade wise, grade wise.
service wise?
Grade wise,
Okay.
grade wise.
So your name will not figure in this
Will
list.
not figure. Now the next page, my lord.
Page
116. So in grade 3, my lord, I become number 1.
Okay.
So my juniors have all been promoted. I have been superseded. Their names are shown in the gradation list of grade 2. I am still number 1, my lord, and now I have become number 1 in grade 3, my lord. Now, pursuant to this, my lord, I have approached the department, my lord, to consider my promotion, to consider me for promotion, my lord. At page 133,
Just page
page 133, annexure 12.
yes.
This is a notification dated 5th of January 2017.
Yes.
By this notification, my lord, I have been promoted. I have been promoted, my lord, which your lordships will find at page 137. Paragraph number 3 of page 137, my lord.
Yes.
In this notification dated January 2017, at page 137, your lordships will see third paragraph, my lord,
Yes.
that is ending number F1. It reads, my lord, in pursuant to recommendation of the departmental committee and under provision so and so, Shri Nathaniel J.D. Shaddap, agriculture officer, is hereby promoted to the post of MAS2. So he has been subsequently promoted, my lord. Subsequently promoted, but kept below his juniors, my lord, who were previously promoted. Now, my lord, pursuant to this, my lord, since I have been placed below my juniors, my lord, I made a representation, my lord, at page 142. Page 142 is my representation, my lord.
Dated.
Well, this is dated, your lordships will find the date at page 145, 2nd of March 2021.
Yes.
If I may read, my lord, because this will be important. Page 142, my lord, paragraph 1. That, sir, I was initially appointed to the post of Agriculture Extension Officer under Regulation 3F of the Meghalaya Public Service Commission, Regulation 1972, white notification dated 26th of October 1988, and was posted in so-and-so, East Garo Hills district. That pursuant to the above, I appeared in the interview conducted by the Meghalaya Public Service Commission on 22nd of August 1989 and stood successful. That white notification dated 6th of January 1990, I was inducted into the Meghalaya Agriculture Subordinate Service Grade 1. Grade 1 is under the old rules. In bracket, I've written old rules, and appointed as research assistant in Tura office of the Research Office District Local Research Station Laboratories. Para 3. In the meantime, the department formulated and notified the Meghalaya Agriculture Service Rules of 1996, which was made applicable to the Agriculture Service. That upon the formulation of the said rules, the post under Meghalaya Agriculture Subordinate Service Grade 1 held by the undersigned was redesignated as Meghalaya's Agriculture Service Grade 3. That, sir, white notice dated so and so, the department prepared the inter se seniority list of the members of the Meghalaya Agriculture Service Grade 3, and I was placed at serial number 102. That, sir, the department white notification dated 10th January 2013 granted promotion to various officers of the Meghalaya Agriculture Service Grade 3 to the higher post following under Meghalaya Agriculture Service Grade 2. That, to my surprise, I was denied promotion, and the officers below me in the inter se seniority list, that is between serial number 103 to 122, were granted promotion. That it is necessary to place on record that I was not considered for promotion and that I was arbitrarily and discriminatorily superseded. Para 6. That, sir, subsequently again, white notification dated 1st of June 2015, the department granted promotion to various officers of the Meghalaya Agriculture Service Grade 3 to the higher posts falling under Meghalaya Agriculture Service Grade 2. However, to my surprise, I was again denied promotion, and the officers below me in the inter se seniority, that is serial number 123 to 144, were granted promotion. That it is again necessary to place on record that I was not considered for promotion and that I was arbitrarily and discriminatorily superseded. That, sir, it was as late as 2017 that I was granted promotion to the Meghalaya Agriculture Service Grade 2, white notification dated 5th of January 2017, and that at present I am serving as Assistant Director Horticulture Marketing so-and-so Williamnagar, Grade 2. That, sir, despite not being promoted, I am listed below my juniors who superseded me during 2013 and 2015. As such, I am highly aggrieved by the same, since I was previously not considered for promotion. That, sir, now some of my juniors have been promoted and reached the levels of senior grade and grade 1, whereas I am still lingering in the grade 2 level for no fault of mine, and it is only on account of non-consideration of my promotion during 2013 and 15 by the department that I am suffering till date. that, sir, throughout my service, there has been no complaints or proceedings against me and neither any negative remark against me. Despite the same, I was not considered for promotion during 2013 and 15 and being made to suffer and the consequences of loss of opportunity. That, sir, the Meghalaya Agriculture Service Rules 1996 provide that the basis and criteria upon which the Departmental Promotion Committee has to consider for promotion is seniority, and that is also categorically provided that in the event a junior member is selected in preference to his senior, the committee shall record in writing. However, in my case, nothing has been communicated to me as to why I was not considered for promotion during 2013 and 2015 along with my juniors. In light of the circumstance, I hereby pray that I may be promoted to the next level. Now, pursuant to this, my lord, no reply from the department. Therefore, I again sent a reminder, my lord. Sent a reminder at page 146. The date your lordships will find at page 149. 9th of August 2021. So I will not read this, my lord. It's a repetition of the previous representation. Now, pursuant to this August 2021 representation, my lord, at page 150, your lordships will find now my promotion from grade 2 to grade 1, my lord. So, my lord, pursuant to my representation, what they do is they consider my next promotion, my lord, from grade 2 to grade 1, which is at page 150, annexure 15. This is notification dated 18th of November 2021. Page 150, my lord.
18 November.
Dated 18th of November 2021.
So you were promoted?
I was promoted, my lord, from grade 2 to grade 1, my lord. Relevant portion is at page 152. Last paragraph. So during the time when I was reclaiming for my seniority, my lord,
Yes.
and for failing to be considered for promotion, I was then immediately considered for promotion at serial page 152, last paragraph, my lord. In pursuance of the recommendation of Departmental Promotion Committee and under provision of Rule 7, Sub-Rule 1 of the Meghalaya Agriculture Service 1996, Shri Nathaniel J.D. Shadap, Assistant Director of Horticulture, is hereby promoted to the post of grade 1.
Yes.
Under level so-and-so of pay. So, my lord, this notification was issued on 18th November 2021 and I was promoted. Then immediately again after that, my lord, at page 156, I made a representation. Now, I will not read the representation again, my lord, because it's a repetition of the, my lord, previous representations. But here the only addition is at para 9 onwards.
Yes.
Para 9, my lord, I'll just take your lordships to
This
page
is
1.
dated?
My lord, this is dated 25th November 2021.
Okay.
This is after my promotion to grade 1, my lord. Relevant paragraph, your lordships will kindly have page 158, para 9.
Yes.
So I say in my representation, my lord, pursuant to my being promoted to grade 1, I say that, my lord, at para 9, that, sir, despite being promoted to grade 1 below deputy director level post, I am again listed below my juniors who superseded me during 2013 and 2015. As such, I am highly aggrieved with the same. since I was previously not considered for promotion, my lord. So the whole my lord, issue arises with effect from 2013, my lord. My loss of opportunity arose in 2013. Therefore, my lord, pursuant to this representation, my lord, I have filed this writ petition, my lord. For, my lord, with the prayer, my lord, your lordships will find at page 13 of my petition is my prayer, paragraph, after paragraph 26. Paragraph 26. After paragraph 26 is the prayer portion at page 13, my lord.
Yes.
My prayer, my lord, somewhere in the middle. So I pray, my lord, in the nature, somewhere in the middle, my lord, in the nature of mandamus to be issued directing the respondent to restore the petitioner to the level of his actual seniority as on 2013. So this was my prayer, my lord, before his juniors was considered for promotion and duly promoted, thereby superseding the petitioner. And in the writ petition, your lordships will kindly have the cause title at page, cause titles, the memo of parties, my lord, starts at page 2 of the writ petition, my lord. The memo of parties. So serial number 6 onwards were arrayed as parties, my lord, private respondents, because at that point in time the petitioner was still serving. Page 3, my lord, serial number 6 is Purnima K. Sangma.
Yes.
So serial number 6, my lord, was Purnima K. Sangma, my lord. And the rest of them, my lord, up to serial number 35, who were my juniors and superseded me, my lord, with effect from 2013 and 15. Now, during the pendency of this matter, my lord, many of them retired, and so did the petitioner retire, my lord.
This serial number 10,
Serial number 6, my lord.
serial number 10 has not been cut off.
All of them have been cut off, my lord, struck off. Because if
Cause title, serial number 10 and serial number
because your lordships will find an order.
32. Anyway, what do you
Yes.
what do you say? All of them have.
Yes, all of them were made parties, but in view of the petitioner retiring, my lord, now all of them are not necessary parties. Nobody will be affected, so they were struck off, my lord. So now, my lord, since he has retired, now the prayer have to be, my lord, molded for notional promotion, that is the restoration of the seniority with effect from 2013. Now the issue that arises, my lord, in the event if your lordships is, my lord, convinced that yes, injustice has been done and the petitioner should have been considered, at least considered. I'm not saying promoted, but considered, and something on record should have been placed as stating the ground as to why he was not considered. Now, assuming if your lordships agrees with my submissions and grants him notional promotion, now the next issue that comes in is, my lord, what are the my lord, entitlements that I'm entitled to? So, my lord, one is back wages with effect from my lord, because I was promoted in 2017. So whether I'm entitled to my lord, back wages with effect from 2013 at grade 2 till 2017. That is the issue, my lord. And subsequently, when I was promoted to the next level also, my lord, then when was my junior, my lord, Purnima K. Sangma, promoted, notional promotion with effect to that, and then senior grade, my lord, again to that. Now, whether I'm entitled to back wages, my lord. Now, back wages is going to be something which even the state is contesting, my lord, because it's going to be a considerable amount, my lord. And since I'm retired, my lord, on the back wages, I will not press, my lord. And that is what I wanted clear instructions from my client. But personally, as a counsel, I would advise him, we need not go to that because we will have to, my lord, cross the hurdle of no work, no pay, my lord. So therefore, we need not labor on that, my lord. So all I'm praying for is, my lord, he be notionally promoted.
I think the jurisprudence on this point has been crystallized.
it has been crystallized, my lord, but there are also judgments, because I came across certain judgments, my lord, when if a person, for no fault of his, he was ready to, my lord, join the post, but you did not permit him to join the post, then you have to pay.
That's what
And that is left
I
to,
remember that.
yes, that is left to the discretion of the honorable court as to up to what percentage, maybe half or 25%, or not at all entitled. That would be sole discretion of your lordships. If I'm able to show that as on that date I was ready to serve, but I was not permitted to serve. But
if you are not pressing the point,
I won't press. That is why, my lord, I wanted instructions. So the only point that is left, my lord, if your lordships consider or directs the department to consider my notional promotion with effect from the date my immediate next junior, that is serial number 103, Purnima K. Sangma, was promoted, then what will have to be done is, my lord, my pay fixation has to be computed, my lord. Pay fixation, increments, and then, my lord, again this subsequent promotion, again refixation of pay without back wages, up to my retirement, my lord, my last pay.
and finally the rate of pension has to be more adjusted accordingly.
According to my last pay, my lord. So that is my only prayer, my lord. I will not press on back wages, subject to what my learned friend will have to say. But I'll just.
But the counter has been filed.
Counter has been filed. I just placed the counter also, my lord.
Have you filed any rejoinder?
Rejoinder I have filed, my lord.
What did the government say in their counter?
I'll just take it, lordships. Government says, my lord, in its affidavit that I was absent from duty. I was absent from duty on a certain, my lord, for a certain period of time. Nothing has been brought on record that there was any kind of disciplinary proceedings against me. Lord, kindly have the affidavit, which is dated, this is sometime February 2023, filed by the respondent number 125, sworn by one Srimati S. Kharsati. So basically, my lord, they have raised the objection of my lord, delay, that I have belatedly approached this honorable court, my lord, and belatedly objected to the seniority list, my lord. And in relation to Rule 7, Sub Rule 3, which provides you have to clearly give a reason when a junior is, my lord, recommended before the senior, they are absolutely silent on that point. Absolutely silent on that point. So your lordships kindly have para 4 onwards. Do you want me to read or you will place it? Page 2, para 4, my lord. Para 4.
Yes.
They say, my lord, that the instant writ petition is also not maintainable in law or in fact as it is barred by the principle of estoppel, waiver and acquiescence, and it is a matter of fact and record that the petitioner was promoted to grade 2 Meghalaya Agriculture Service in the year 2017 and to the post of grade 1 below deputy director level of Meghalaya Agriculture Service in 2021, which the petitioner accepted without raising any objection. Failure to object the seniority list at the first available opportunity and raising objection to the promotion given to the private respondents in the year 2013 and 15 after a period of 8 years as erroneous, arbitrary and discriminating, and claiming position ahead of the private respondents at this stage is highly incorrect, untimely and inappropriate. Hence, action on the part of the petitioner, waiver to object and consequent acceptance of the seniority position on this ground also the instant petition lacks merits and deserves to be rejected. Then, my lord, may kindly have para 8.
Yes.
Kindly have para 6 first, my lord. they say in para 6, my lord,
Yes.
that the averment made in paragraph number 2 of the writ petition is partly true insofar as place of posted of petitioner at the time of filing of the instant writ petition is concerned. However, it is false, denied, and incorrect to state that the petitioner has been arbitrarily and illegally denied promotion by the answering respondent as a result of which being superseded by the private respondents herein. So, my lord, in paragraph 6, they say he has never been denied consideration and he has never been superseded. Now, para 8, my lord. In reply to averment made in paragraph 10 and 11 of the writ petition, the answering respondent states that it is a matter of record that the answering department herein have prepared an inter se seniority list, notified and promoted its employees time and again in the year 2013 and 2015 respectively. However, it is also a fact that the petitioner have never objected to the same, and there is no ground in place to show he was aggrieved or prejudiced by promotion given to private respondents, which hence shows that the petitioner was not deprived and have willfully accepted the decision of the department. It is hence denied as incorrect that the promotion was made arbitrary and discriminatory. All promotions were by following the relevant rules. So if they say that the promotion were followed, all promotions were by following the relevant rules, my lord, they would have brought on record by way of this affidavit the reasoning showing that why the juniors were recommended. However, there's nothing on record. Rules applicable at the point of time without causing prejudice to the writ petitioner. The
So
petition,
your first representation was in 2021.
yes, my lord, 2021.
Yes.
Prior to that, my lord, if your lordships recollect, 2013 was the first promotion, 2015 was the second promotion. Thereafter, gradation list came in January 2016. I approached the department. I did not write a representation, but I was following up with the department. Therefore, the department considered my promotion then in 2017. They considered my promotion, but after considering my promotion, after promoting me, I then find that I'm still below my juniors. So that is from where the grievance started, my lord. That subsequently you have promoted me, but then why am I being shown below the juniors?
You see, it would be incumbent upon you to have approached the authorities at the
First instance.
First instance.
Yes, my lord.
You should have done that.
Yes, my lord.
There's no explanation to why you.
No, my lord. There's no explanation. There's no explanation, my lord. Then, my lord, may I kindly have para 9.
Yes.
That the averment made by at paragraph number 12 of the writ petition is denied and untrue. No representation or objection was ever received by the petitioner from the petitioner in respect of inter se seniority of 1997 or promotion given in the year 2013 and 2015. This is what your lordships has just put the query to me, my lord.
Yes.
The rest of the paragraphs, my lord, are all the same, my lord, denying that I have been superseded and saying that I have belatedly come to this, made a representation, my lord. So that is the stand of the department. And at para 16, something new comes up, my lord.
Yes.
Para 16, they state, my lord, that I was absent from May 2012 to September 2012, and there is an annexure, my lord, at page 8, which they have enclosed and made the statement in para 16. So this is what they are, my lord, placed before your lordships, that a notice was issued to me, my lord, for being absent. Now, pursuant to this, my lord, this is 2012, pursuant to this, my lord, or after this, my lord, nothing has been brought on record that there was any kind of disciplinary proceedings against me, my lord, that would affect my consideration for promotion. So that is what has been stated by them, my lord. I have then, my lord, filed a rejoinder, my lord. And at para 8, my lord, I have stated, my lord, your lordships has my rejoinder
Rejoinder dated
dated 13th of June 2023.
yes. Para
Para 8, my lord, I have stated my lord, that the petitioner further states that it is the duty of the state respondents to ensure that its actions are in accordance with the law and that justice is upheld at all times. Therefore, it is not the responsibility of the petitioner to raise objections, but rather that of the state respondents to perform its duty in fair and just manner. Para 9, I have cited a judgment, my lord. I have cited this judgment, my lord. I'll just so para 10, my lord, I have again stated. Para 9, I have cited this judgment, my lord, reported in 2017, volume 9, SSC 379, and I'm relying on paragraph 14. It's there in the rejoinder, I don't know. I've cited
Para 14. What does you see?
I'll just try and get the entire judgment. That's why my colleagues have just put this in, but I'll just take your lordships.
Whether you say it or not, this principle will be applicable.
I'll just take your lordships now to para 12 regarding my absence. It says, my lord, it is pertinent to mention herein that there are no negative remark in the ACR of the petitioner, which indicates that there was no valid reason for the state respondents to deny promotion in the year 2013 and 14. Now, my lord, on consideration of promotion, I'll just place.
Mr. Nobri,
Yes, my lord.
when it comes to para 12,
Para
as far as this ACR is concerned,
Yes, my lord.
this pertains to the year 2013.
My lord, there I'm talking about the 2012, 2013. My lord.
Okay, whatever the case may be.
Yes, my lord.
Let's say 2010, 11, 12, 13, whatever.
Yes, my lord.
Were you communicated as to...
No, my lord.
Because that is the rule, isn't
Yeah,
it?
yes, my lord. That if there anything negative, I should be communicated.
Negative or positive,
Nothing
you
was,
have to be.
nothing was
As
communicated.
to what is your grading.
Yes, my lord. And as per rule 7.3, my lord, if there's any ground recorded as to why juniors were promoted, that also were, my lord, not communicated to me ever, my lord.
Of course, if there are negative observations, you will be given chance to show cause
Show cause, my lord.
or file a representation within that
Correct,
15 days period, whatever.
Correct, my lord.
That has not been done.
That has not been done.
Neither was the the gradings of the ACR informed to you.
Yes, my lord.
Have you stated that in your any of your offense?
No,
Because that
but,
would be material.
I've stated in my rejoinder that there's nothing negative in my ACR. That's all I've
So
stated.
that means that means you know that what is there in your ACR. You've been communicated as to what have been
Yes,
your,
my lord.
what is your grading in your ACR.
What I'm trying to say is there's nothing in negative, my lord.
Okay, nothing.
Yes,
the
my lord.
query of the court is where you at all you inform of your gradings as far as your ACR is concerned.
My lord, the only statement that was given by the petitioner was that there's nothing negative. Now, whether he was communicated, obviously he'll know, because he knows that there's nothing negative, so he'll know that it's communicated. But that specific communication, I can seek instruction. That is not a problem.
Because that would be important. Because
Yes.
then you see you would have an ammunition against the authorities.
Yes, my lord. Yes. But my lord, the reasoning under Rule 7.3, why the juniors were promoted, that was never communicated to me. That was
you
never.
see, more often than not,
Yes, my lord.
that reasoning would be based on
The
the
is
observation made, or rather the grading made in the ACR.
ACR, my lord.
And like you rightly said, if there are any DP
Yes.
against the incumbent or which, so that is also
Yes.
taken into account.
Yes, my lord.
Cumulative reasons will be given,
Correct, my lord.
but then
So that is not there, my lord. No DP, my lord. No communication under Rule 7.3. I'll just.
you have not specifically spelled out that
Yes.
that contention.
I'll just cite only one judgment, my lord. I will not burden your lordships. Your lordships kindly have. This is on right to be considered for promotion, my lord. That right to be considered for promotion is a fundamental right, my lord. This is, my lord, a constitutional bench judgment reported in, my lord, 1999, volume 7.
Principle of legitimate expectation.
No, my lord, this is fundamental right to be
Fundamental
considered.
right.
Yes, my lord.
Para.
Your lordships will have, this is a constitutional bench judgment. Your lordships will kindly have para 21 onwards.
Para 21.
Para 21 onwards, my lord. In fact, it will be para 22, but the heading before para 22, they write what the court is my lord, discussing about. So before para 22, the line above, it reads, my lord, Article 14 and 16.1 is right to be considered for promotion of fundamental right. So this is the question which the constitutional bench was dealing with in this judgment, my lord. Para 22 onwards, I'll just read, my lord. Article 14 and Article 16.1 are closely connected. They deal with individual right of the person. Article 14 demands that the state shall not deny to any person equality before law or the equal protection of laws. Full stop. Article 16.1 issues a positive command that there shall be equality of opportunity for all citizens in matters relating to employment or appointment to any office under the state. It has been held repeatedly by the court that clause 1 of Article 16 is a facet of Article 14, and that it takes its root from Article 14. The said clause particularizes the generality in Article 14 and identifies in a constitutional sense equality of opportunity in matters of employment and appointment to any office under the state. The word employment being wider, there is no dispute that it takes within its fold the aspects of promotions to the post above the stage of initial level of recruitment. Article 16.1 provides to every employee otherwise eligible for promotion or who comes within the zone of consideration a fundamental right to be considered for promotion. Equal opportunity here means the right to be considered for promotion. If a person satisfies the eligibility and the zone criteria but is not considered for promotion, then there will be a clear infraction of his fundamental right to be considered for promotion, which is his personal right. Promotion based on equal opportunity and seniority attached to such promotion are facets of fundamental right under Article 61. So, my lord, equal opportunity and seniority, my lord. Because if equal opportunity is not granted, then he loses on seniority. That is what at para 23 onwards the Honorable Supreme Court discusses, my lord. Where promotional avenues are available, seniority becomes closely interlinked with promotion, provided such a promotion is made after complying with the principle of equal opportunity stated in Article 16.1. For example, if the promotion is by rule of seniority cum suitability, the eligible seniors at the basic level as per seniority fixed at that level and who are within the zone of consideration must be first considered for promotion and be promoted if found suitable. If the in the promoted category, they would have to count the seniority from the date of such promotion because they get promotion through a process of equal opportunity. Similarly, if the promotion from the basic level is by selection or by merit or any rule involving consideration of merit, the senior who is eligible at the basic level has to be considered, and if found meritorious in comparison with the others, he will have to be promoted first. Then, your lordships, I'll just then straight away take your lordships to the next page. Before para 24, the heading reads, right to be considered for promotion is not a mere statutory right. So this is what the Honorable Supreme Court, the Constitutional Bench discussed. So para 24, it reads, the question is as to whether the right to be considered for promotion is a mere statutory right or a fundamental right. Then para it discusses certain judgments, and then at para 27, it gives its opinion. Para 27.
Yes.
In our opinion, the above view expressed in Ashok Kumar Gupta and followed by Jagdish Lal and other cases, it is intended to lay down that the right guaranteed to employees for being considered for promotion according to the relevant rules of recruitment for promotion, that is whether on basis of seniority on merit, is only a statutory rules and not a fundamental right. We cannot accept this proposition. So the Constitutional Bench said that the proposition given in the two above judgments, that it is only a statutory rules, it did not accept, and it finds, we have already stated earlier that the right to equal opportunity in matter of promotion in the sense of a right to be considered for promotion is indeed a fundamental right guaranteed under Article 16(1), and this has never been doubted in any other case before Ashok Kumar Gupta, right from 1950. So I'm just placing this judgment, that my fundamental right to be considered have been violated, which is also provided under the rules that they have to give reasoning. That has not been done, irrespective whether I'm belated before this court or belated representation, that will not affect my fundamental right. I'm still entitled to raise my rights. So that is my submission.
Yes, proceed.
Lordship, I was actually informed by my friend that perhaps he won't be doing this case today. Will your lordships kindly have this tomorrow?
Yes. Well, I thought I would seek instructions, but
How long would you?
no, I don't require any instructions. No, I have completed my submissions,
No, on the other aspect, the back wages thing.
On the back wages, I won't press anymore. I'm making my statement. It is only fixation of pay, notional promotion with effect from 2013, and then subsequent pay fixation. That's it.
So you're tying the hands of the court. If the court is inclined to give you back wages, then finish.
Yes, ma'am.
Heard Mr. Liman Council of Justice. Mr. SN GA has submitted that he may be allowed to reply on the next date. As agreed to by the parties. This is matter.
Okay.
Second.
28.
No.
Five.
This is matter tomorrow
Obligement.
for further hearing.
Second call from supplementary list, item number 1.
Please, Your Lordship, I'm appearing for the private respondent, respondent number 3. I'm praying the matter can come up after 2 weeks, Your Lordship, because the conducting counsel, Mr. P. Nongbri, is still in bereavement. Because this is an application where they're praying for stay of the proceeding before the trial court. So I'm praying for 2 weeks' time, Your Lordship.
Why 2 weeks? 1 week?
Next week, then, Your Lordship.
Next week I am not available, Lordship, from 3rd onwards, Lordship.
Okay. So you agree on a date then?
Lordship, by the meantime, Lordship, lower court's record may be called for because I have to prepare paper books and all, Lordship. Because lower court's record has to
Appeal
be...
has not yet been admitted.
No, Lordship.
So I have to hear the parties on
Lordship.
decision.
Lordship.
They may have to see something.
Lordship.
So we'll fix it on no.
Lordship, I am not available on 3rd, 4th and 5th, Lordship. Thereafter it can be fixed, Lordship.
We'll have it on 8th then.
Your Lordship.
8, Lordship. Yes, Lordship.
8th is Monday.
Monday, Lordship.
Ms. P. Procedural, counsel for the appellant is present. However, all the respondents are,
Lordship,
you
yes.
know, in attendance.
Yes, Lordship. All the copies are served, Lordship.
So notice is not required.
No, Lordship.
And I submitted that all the respondents herein are duly represented by their respective counsels. As such, no formal notice is not required. This court would acknowledge the same. Next, this matter is fixed today for admission. This appeal is fixed today for admission. However, Ms. Leonard Sutanga, Leonard Counsel for the
Respondent number 3, Your
respondent
Lordship.
number 3 has sought for accommodation on the ground that the Leonard conducting counsel, Mr. P. Nobri, is in bereavement. Accordingly, as prayed for, this matter as accordingly as agreed to by the parties, this matter on 8th
Highly obliged, Your Lordship.
for admission.
Lordship.
Lordship, in item number 3, we have concluded our submission, and Lordship's desire only to give the bullet points. Now, my colleague is supposed to submit today.
We are filing it, Your Lordship.
Item number 3.
You have finished. You have. I mean, have you submitted your?
Yes, Your Lordship, I have submitted.
Mr. Indishulai Leonard, AG has submitted the written argument on behalf of the appellant state. Accordingly, this matter is reserved for judgment.
Apply, Your Lordship.
May it please your Lordships. Lordships, I beg to make a mention of item number 4, Lordships. Lordship Senior Counsel Mr. Paul is having some personal difficulties today. I'm praying if this matter may be listed on Friday, Lordship.
No objection. Not on Friday. Friday, are we sitting Friday? Is this court sitting on Friday?
Next week, Lordships.
Lordship, we have already concluded our arguments.
You have concluded?
Lordship.
On plea made by Ms. Leonard Counsel, seeking accommodation on behalf of the Leonard Senior Conducting Counsel, Mr. K. Paul, who is said to be indisposed. Matter is adjourned. Please system after 1 week.
Highly obliged, Lordships.
May I please your Lordship? Lordship, I beg to mention item number 10, Lordship. I'm praying for 3 weeks time, Lordship.
Number?
10, Lordship.
10?
Yes, Lord.
On pre-made by the appellant, this is matter after 2 weeks.
Similar prayer for item number 12, Lordship.
Plus, same order.
Obliged, Lordship.
Please, Your Lordship. Lordship, in item number 1, we have concluded our submissions, and we've also filed our written submissions, Your Lordship.
I have also filed written submission.
Item number 1, sir.
This item number 1, this court is desirous of passing a common order as far as 1 and 2 is concerned.
Yes, sir.
So,
This is Your Lordship. Lordship, item 2 is analogous with item number 1.
exactly. Even it's,
I am appearing in item number 2.
who is away, you or you? Okay. You have not started your.
No, we have not started.
So we'll start with the lordship. Okay.
Let item number 2 started. Accordingly, we can fix the item number 1 also, lordship.
But since written argument have been filed, so we'll
We
reserve.
have completed item number 1. We have completed.
You have filed.
We have
Yes,
already
we have
filed
filed.
our
Both-
written submissions
both
also,
of
Your
us.
Lordship.
Talk to you know, both parties have filed their respective written argument. Judgment reserved.
Obliged.
Obliged, Your Lordship.
May I please, Your Lordship? Your Lordship, I beg to mention item number 5. On behalf of LSC M. Sharma, Your Lordship. Your Lordship is having some personal difficulties. Let the matter come after 3 weeks.
On pre-made with the appellant, this is matter after 3 weeks.
Similar prayer for item number 9, Your Lordship, after 2 weeks.
Nine. 2 weeks.
Obliged, Your Lordship.
Please, Lordship. I beg to mention item number 8, Lordship. Humbly pray for 2 weeks' time, Lordship. Matter.
8. 2 weeks.
Obliged, Lordship.
May please your lordship, I beg to mention item number 13.
Number?
Item number 13.
For 3 weeks, yeah.
Kindly fix the matter after 1 week.
How long?
After 1 week, your lordship.
1 week.
Much obliged, your lordship.
Excuse me.
On daily list, item number 1. Item number 2.
May it please your lordship. Here in this case, your lordship already heard the facts of the present case, but still there are some few facts which I think I need to place before your lordship. So lordships may kindly come to page number 2, that is the FIR.
Just page
2.
2.
Yes, sir.
Yes.
Here your lordships will note that the FIR was lodged on 13 July 2016 and incident is of 12/7/2016 at 8 a.m. There is delay, and how that delay is fatal in the present case I will place before your lordship. And second thing,
lodged on
13 July 2016.
Yes. Incident
12/7/2016 at 8 a.m.
One day delay.
1 day delay. How that is delivered, I will place before your lordship. And second thing, your lordship may kindly note that there in the FIR, 4 persons are named. He is not the eyewitness. Informant is not the eyewitness. He heard it from some other persons.
Yes.
And second thing, your lordship, and another aspect your lordship will see that in the present FIR, there is no role ascribed to the alleged eyewitnesses, whether they were present or the informant heard from those persons. That is not mentioned in the FIR. And the person who, the victim, he was alive till 2 p.m. That is mentioned in the FIR itself. Down below, your lordship will get last 4 lines. That on 12/7/2016 at about 2 p.m. he died on the way to hospital. Now lordships may kindly turn to page, I'm referring to the seizure list, just I'm mentioning the page number, lordship, page 42. And type copy your lordship will get at page 43.
Yes.
This lord, here your lordship will get that GD number is there 8 of 12/7/2016 detail. And time your lordship will get 10:30 a.m. on 12/7/2016.
Yes.
So on same day police arrived at the PO, but no FIR was lodged. It was lodged on on the subsequent day, lordship. So identified by eyewitnesses, third line of that seizure list, your lordship will get after being identified by eyewitnesses. So
Yes.
eyewitnesses were also present, but in spite of that, FIR was not lodged. Now lordship may kindly turn to page number 15. This is the 161 statement of the eyewitnesses, although it is not very relevant, but for facts I am placing before your lordship. Your Lordship will get it that Fulbury PR GD entry, top portion your Lordship will get that Fulbury PR GD entry 8 dated 12/7/2016.
Yes.
So their statements were recorded and all three witnesses deposed exactly same, like depositions. And in their statements, they stated about 3 persons. Should I read it, Lord?
Yes, please.
Examined her, and she says, I am a housewife and sometimes work as cultivator. I am an eyewitness to the instant case. On 12/7/2016, at about 8 a.m., while I was making tea. Lordship may kindly note that part because all three eyewitnesses stated that they were making tea. That is the coincidence. I was making tea at a kitchen. I heard some noise outside. When I looked, I saw Sri Bodial Sheikh was running, and from his behind, 3 more persons following him. In the FIR, 4 persons. The eyewitnesses stated about 3 persons. He entered at one of the house of Islam Hall and tried to bolt, but 2 persons who followed did not give him a chance and both entered inside the house and bolted. 1 person remained outside. I heard they beating him. I rushed to see what happened inside the house, and my friends also followed suit. From the window of the house, we saw that both the persons beat Sri Bodial Sheikh black and blue by lathi. A stick used for crushing rice traditionally. We are all ladies and helpless, just shouted to stop beating him, but they did not listen. When they finished beating him, they opened the door and pushed the victim outside in the compound, where he lay in a pool of blood, and they fled away from the scene. Later, the public arrived and they shifted the victim to Fulbury CHC for treatment, and he was referred to higher hospital for treatment. That's all I have to say. Now, here, Lordships, you will not get the name of the accused person. Whether they have identified the accused persons, that is also not mentioned. Because why I am placing that fact? Because in the FIR, the informant was not the eyewitness. He named 4 persons. How these persons were identified and by whom? There is a gray area in that aspect, Lords.
Yes.
Because they were arrested and thereafter TIP was conducted. So it is of the TIP I am challenging that TIP is not in conformity because it was conducted in presence of IO. So that TIP part goes. And how these accused persons were identified, there has to be something, but that part is not there. Therefore, I have placed the 164(1) statement before your Lordships. Now, your Lordships may kindly see the statement of the informant in 161. That your Lordship will get page 18. How these persons were identified, he is also not disclosing that fact, from whom he came to know about the names of assailants.
Yes.
Examined him and he says, I am a driver professionally and Bodial Sheikh is my brother-in-law who was of Assam Gwalpara area. He used to come and work in my village sometimes as a laborer. On 12/7/2016, I left my home early in the morning to Tura by vehicle which I drive. My brother-in-law was in my village for some work. Suddenly at noon, I get a phone call from my relative who informed me that my brother-in-law, late Bodial Sheikh, was beaten badly by Khalil Sheikh and his group, as a result of which he succumbed to his injury on the way to hospital, which was referred from Fulbury, CHC. I came to know from the public that on 12/7/2016, at around 8 a.m., while my brother-in-law went to Kalitan market, on the way near the bazaar, the accused persons, namely Sri Khalil Sheikh, Basudur Sheikh, Ukil Sheikh, and Jahanur Sheikh, suddenly attacked him. My brother-in-law anyhow ran away from there and went to my relative's house, Islam Hall. to seek help, but unfortunately no man, only woman who cannot help him. The aforesaid accused persons went there also and assaulted him by lathi, as a result of which he received head injury and died on the way to hospital after being referred from CHC Fulbari. Also, Khalil Sheikh's daughter gets married to a boy from my brother-in-law's area. The boy had been introduced, so this part is not relevant. So he heard from public or relative, but those persons' names he did not disclose. Now, your lordships may kindly see the evidence part. I am only reading the eyewitnesses. That page at page 19, PW1.
Yes.
I received summon to depose on court today. On 12/7/2016, when Bodial Sheikh went to Kalitan market at around 8 a.m., he was attacked by Khalil Sheikh, Basidur Sheikh, Johinur Sheikh and Okil Sheikh, and somehow Bodial Sheikh managed to escape to his relative's house, Islamul Haq, which is nearby the market. But the four accused persons followed him there, and out of the four, three of them, Sheikh Khalil Sheikh, Bodial Sheikh and Okil Sheikh, entered the house and beat Bodial Sheikh. Now three persons entered here with lathi and wooden pestle. While beating him, the accused had closed the door of the room, and after beating him, they opened the door and fled away, leaving the victim there in the room. The victim had received head and chest injury. People gathered there at PO took the victim to the Fulbari police station, and police from there took the victim to the Fulbari hospital, who, after administering him first aid, had referred him to Guwahati for better treatment. While taking the victim to Guwahati, but on the way near Halidanga, he succumbed to his injuries at around 2 p.m. on the same day, 12/7/2016. Thereafter, the dead body was brought to Fulbari PS and police sent it to Tura Civil Hospital for postmortem. Thereafter, we received the body for the last rite. The victim is my brother-in-law. On 13/7/2016, I lodged the FIR with Fulbari PS. I identified all three accused persons in the court today, whom I know both their names and faces being from same village. But I saw Basidur Sheikh outside the court. Basidur was sent to JJB. Now cross part page 20. Day of incident. I was at home at Puskunipara. I have not seen the incident with my own eyes, but I received information over phone from one villager about the incident and the involvement of the accused person. Who is that villager, that is not disclosed. Because Lordship, what I have placed before Lordship, that in 161 statement, the three eyewitnesses, they did not name anyone.
Yes.
So this must be some other person who saw the assailants. The affair lodged by me was written by one vendor of Fulbari on my explanation, and I do not know the contents of the FIR, as I do not know how to read and write. The vendor did not read over and explain to me. After the incident, police also seized the stick and pestle from the residential compound of Islam Haq, which has been shown by one lady whose name I do not remember. It is not a fact that I have deposed falsely before this court. So this is the informant's statement. Now, PW2.
Yes.
Page 21. I received summon from the court on 12 June 2016 at about 8 a.m. After washing my face, I was making tea at kitchen. And when I looked outside from the kitchen, I saw one person was running, and from behind, 3 to 4 persons were following him. But in 161, they say 3 persons were following. He entered house of one Islam. When the victim whose name I do not know, entered into the room. Along with him, one accused, Abdul Khalil, also entered into the same room. Then they locked the room. I rushed to the spot to see what happened outside the house, inside the house, and some of my friends also followed me. From the window of the house, we saw that the victim was being beaten by the accused with a stick used for crushing rice traditionally. Now here, Lordship may say that one stick, one stick the eyewitnesses said, and one stick is seized in the present case. But who used those sticks, that is not specifically stated by these witnesses. Because in the inside house, there was two accused persons. We also saw the victim was being beaten by two persons. And since we are helpless, we just shouted to stop beating the victim, but they did not listen. When they finished beating him, they opened the door and pushed the victim outside the house where he fell and lied down, and the accused fled away from the scene. People from locality to the spot, and they informed the police, and the victim was taken to police station, and thereafter police took the victim to hospital. Later, police called us for TIP to the jail, where accused along with many people were made to stand in front of us, and I identified the accused Abdul Khalil from amongst them. And today, the accused Abdul Khalil is present in the dock, and I know him by name and face. Here, just I am making one thing clear before your lordships, that when TIP was conducted, only Abdul Khalil was subjected to TIP. Other accused persons were not subjected to TIP, and why they were not subjected to TIP, regarding that prosecution is silent. Cross. Defense Counsel. I am a resident of village Bolavita, and the incident took place at Kalida. I do not know the residence of the accused Abdul Khalil. I do not know the father's name of the accused. However, the accused used to visit the house of Islam Haq, where I stay as a teenager. Prior to this incident, I have never talked to this accused person. It is a fact that I do not know the name of the victim, but it is a fact that accused Abdul Khalil and another person whose name I do not know ran after the victim. So in 161, they say 3% chased. In examination in chief says 4% chased. Here you see Abdul Khalil and another person. It is a fact that I have not seen the beating by the accused person, as I was standing outside the house and the door was closed from inside. So she admitted that she has not seen the assault part, because that is the relevant, because one stick was used. Along with me, another lady, namely Irani, was also present. Thereafter, the door was opened and the victim was left inside the house. The house owner, Islamul Haq, was not present at the time of incident. So this part is contradictory to other eyewitnesses. Some says he was present. It is not a fact that though the door was closed and no such incident took place inside the house. It is not a fact that whatever I have deposed before this court are false. It is also not a fact that I have not seen the incident and I have deposed falsely. Re-examination. The incident took place inside the house of one person, Islam Haq, and the place is known as Kalida. And I at that time, I was a teenager in the said compound. Now, PW3 says another eyewitness, page 23.
Yes.
I know why I am in the court. I received a summons from the court. I am an eyewitness in this instant case. On 12/7/2016 at about 8 a.m., while I was making tea at the kitchen, I heard some noise from outside, and when I looked outside, I saw Sri Bodial Sheikh was running, accused Abdul Khalil along with three other persons were following him. So this is exactly same as PW2. Now this is like parrot-like deposition. Among that, I will rely on some citation before your lordships. The victim Bodial Sheikh entered the house of one Islam Haq, and along with the victim accused Abdul Khalil and his son also entered inside the house and locked the door. When we rushed to the spot to see what is happening, we saw from the window of the house that both the accused persons were beating the victim Bodial Sheikh with a stick, which is used for crushing rice traditionally. As we are unable to enter the house, so we just shouted from outside to stop beating the victim. But they did not listen. When the accused finished beating him, they opened the door and pushed the victim outside, where he fell and lay down on the ground outside the house. And the accused fled away from the scene. Later on, the public arrived on the spot, shifted the victim to the Fulbari CHC for treatment, and later he was referred to Gwalpara. And on the way to Gwalpara, the victim expired near Tikir Khila. After a few days, a notice was served, and accordingly, we reached Turaje, where I identified accused Abdul Khalil amongst the other persons. And today, the accused Abdul Khalil is present in the court dock, and I know him by name and face. I also know the other accused who are present in the dock today by name and face, namely Okil and Joel Cross. My residence is at Sibinan under Fulbari PS. The accused persons are from village Puskunni Para. I know the victim Bodial Haq as his father-in-law's house is near my house. I have seen the accused persons were running after the victim Bodial Haq. On the day of incident, there was nobody in the house of Islam Haq. I do not know the reason why the accused persons had beaten the victim. It is not a fact that since I was standing outside the room, as such, I had not seen anything who was beaten and by whom. It is not a fact that whatever I have deposed in my chief is false. I have not given my statement before the magistrate. The victim is not related to me, and I came to know of the accused persons after the incident only from the villagers. So before TIP, he came to know about the accused persons from the villagers. It is not a fact that no such incident ever took place. Re-examination by prosecution. The incident took place at Puskunni Para. Now, PW4, page 25. I received summons to appear before this court today on 12 July 2016,
See,
where I was...
What do you mean to bring out from all, reciting all this deposition?
The serial number 10, cross part lordship. The victim is not related to me, page 24, says that victim is not related to me, and I came to know about the accused persons after the incident, only from the villagers. So names, how disclosed, who disclosed, that part I'm stressing out.
Okay.
Because the FIR was lodged subsequently. The informant do not know who caused that incident, who are the assailants. So how that identification part came, only on to stress that part I have pointed out.
Okay.
Now page 25, PW4. I received summons to appear before this court today on 12 July 2016, when I was preparing tea at my home. I heard the shouting of some people outside the house. So I went outside the house and saw that one person was running, Bodial Sheikh, and behind him, 3 persons were running after him. The person who was running entered the house of one Islam Haq, and the persons who were running after him also entered inside the same house, and they locked the door from inside. I heard them beating the deceased, and from the window of the house, I saw that the 2 persons were beating up Bodial Sheikh by a lathi. I shouted at them to stop, but they did not listen. They beat the deceased with a wooden stick used for grinding rice. When they finished beating him, they opened the door and pushed the victim out of the house, and they fled away from the scene. The persons who assaulted the deceased are present in the court today, and I can identify the accused who assaulted the deceased as Abdul Khalil, Okil, and Jahanur. Thereafter, the relatives of the deceased informed the police. Victim was lying in a pool of blood till the time the police reached the PO. So now this line, Lordship may kindly note, the victim was lying in pool of blood till the time police reached the PO. But no dying declaration was recorded by the police.
Yes. Yes.
Now cross part, Lordship. Page 28, Lordship.
Yes.
I am a resident of New Puskunipara. It is a fact that alleged victim Bodial Sheikh is not related to me. It is a fact that I am originally from Assam, but I am staying in Meghalaya in a rented house. I do not do anything as a living, as I depended on my son, who is a bread earner for my family. I am staying in a rented house that belongs to one Islam home. It is a fact that the alleged accused are not known to me prior to the incident. It is a fact that when the alleged incident took place, I was in another room at a kitchen. It is not a fact that I have not witnessed the alleged incident. It is a fact that my statement was recorded by police. My statement was not recorded by the magistrate. It is fact that the family members of Islam Hawk was also present at the time of incident. So, Lordship, this part, it is a fact that the family members of Islam Hawk was also present at the time of incident. But none of the family members were examined in the present case. And to substantiate that, Lordship may kindly say page 42 again, that seizure list. Type copy at page 43.
So there are only three seizure eyewitnesses.
Three eyewitnesses. Police seized those articles from the PO, that is the House of Islam Hall. Other members were present. Nothing was, no one came up saying that these are the assailants. No FIR was lodged. And in the third line of the seizure, it is said, after being identified by eyewitnesses. Now here signatures your Lordship will get Muhammad Ishaq Ali and Abdul Mannaf Sheikh. This witness number 1 and 2 was not examined in the
No, they are seizure witnesses. They are not eyewitnesses.
But in the seizure list, they said being identified by the eyewitness.
Oh, yes.
Third line.
Yes. Yes, please continue.
Yes. And regarding TIP, Lordship, just one line I will show you, Lordship, that page 33. Fifth line from bottom, Lordship, page 33. The IO was present when the TIP was conducted. So this is stated by the judicial magistrate who conducted in whose presence the TIP was conducted. Fifth line from bottom of page 33. The IO was present when the TIP was conducted.
This, okay.
And second thing that in Chief Lordship, third line, Lordship, may I see the name of the accused person, that chief portion, Lordship, third line from bottom. The name of the accused person of this case is Abdul Khalil. So against one person only TIP was conducted. Why others were not subjected for TIP, that explanation is not there.
Yes.
So my whole submission to your Lordship is that first thing that the witnesses deposed like parrot, Lordship, for in the 161 statement as well as in their deposition. So they are not reliable at all. And in this regard, Lordship, I am relying on a citation, Lordship, that AR 1997, which I have given to my colleague, just he may hand it over. AR 1997 SC 3954. Paragraph 5.
Five.
5. May I read, Lordship?
Yes, please.
We have very carefully gone through the judgments of both the high courts below, and with respect, we find that notwithstanding the concurrent judgments thereof, we are unable to sustain the convictions of the appellants on any count. It is well settled that this court would be slow in interfere with the findings of facts recorded by the courts below, which are based on appreciation of evidence. But we are of the considered view that the Sessions Court as well as High Court have mechanically read the evidence of eyewitnesses and totally ignored the well-known principle of appreciation of evidence of PW 2, 3, 5, and 6, who claim to be eyewitnesses. If we compare the evidence of these eyewitnesses, it is immediately noticed that their evidence is just like a parrot, telling about what is taught. Even the omissions, contradictions, and improvements are identical. The claim of these eyewitnesses is totally unbelievable. When they testified that they had gone to the place of occurrence, the distance between their houses and the place of occurrence is said to be 1 fathom. It was night time and the only light available was that of the moon. So rest I am not reading out, Lordship. The main thing is that here also your Lordship will find that in 161, all the 3 eyewitnesses said that 3 persons were
yes,
who were chasing the victim. In 160. Am I audible, Lordship?
yes, yes.
Lordship, I kindly see the another citation which I have given, Lordship, 2003 3 SCC 355. Here, Lordship, paragraph 12 to 16.
Yes.
Another paragraph 12 I am reading, Lordship. Another doubtful factor is the delayed lodging of FIR. The learned counsel for the appellant highlighting this factor. Here it is worthwhile to refer to Lika Kali versus State of Tamil Nadu, wherein the delayed filing of FIR and its consequences are discussed. At para 12, this court says, first information report in a criminal case is an extremely vital and valuable piece of evidence for the purpose of corroborating the oral evidence adduced at the trial. The importance of the above report can hardly be overestimated from the standpoint of the accused. The object of insisting upon prompt lodging of the report to the police in respect of commission of an offence is to obtain early information regarding the circumstances in which the crime was committed, the name of the actual culprits and part played by them, as well as the names of eyewitnesses present at the scene of occurrence. Delay in lodging the first information report quite often results in embellishment, which is a creature of afterthought. On account of delay, the report not only gets bereft of the advantage of spontaneity, danger gets in of the introduction of colored version, exaggerated account, or concocted story as a result of deliberation and consultation. It is therefore essential that the delay in lodging the first information report should be satisfactorily explained. This is the position consistently followed by this court in Maharaj Singh versus so and recently in so. As feared by the learned counsel for the appellants, the possibility of subsequent implication of the appellants as a result of afterthought may be due to political bitterness cannot be ruled out. This fact is further buttressed by the delayed placing of FIR before the magistrate. Non-satisfactory explanation given by police officer regarding the blank sheets in Exhibit P30, counterfoil of the FIR, and also by the closely written bottom part of the so-and-so. So this part I am skipping. Last line of paragraph 14. Moreover, the prosecution did not satisfactorily explain the delayed lodging of the FIR with the magistrate. This court in Marudanal Agasti versus State of Kerala, while deciding a case which involves a question of delayed dispatch of the FIR to the magistrate, cautioned that such delay would throw serious doubt on the prosecution case. Whereas in Arjun Sensor, it was reminded by this court that the forwarding of the occurrence report is indispensable and absolute, and it has to be forwarded with earliest dispatch, which intention is implicit with the use of the word forthwith occurring in section 157 CRPC, which means promptly and without any undue delay. The purpose and object is very obvious, which is spelled out from the combined reading of section 157 and 159 CRPC. It has the dual purpose. Firstly, to avoid the possibility of improvement in the prosecution story and introduction of any distorted version by deliberations and consultation. And secondly, to enable the magistrate concerned to have a watch on the progress of the investigation. One more aspect considered by the trial court was that though PW 28 SIO police proceeded to the spot on getting information of the clash within half an hour, and although he had definite information and details of the incident, which he noted in the general diary, exhibit FIR was not registered on the ostensible ground that the names of the assailants were not known. In here also, Lordships may kindly see the charge sheet. I'm just placing for Lordship.
In this case you are referring, how much is the delay
from the paper book, Lordship?
Huh?
From the paper book, page C.
No. Here in this case you have cited this case of Rajivan.
Yes.
This is with regard to delay in filing FIR.
Delay in the filing FIR.
How long is the delay here?
Here, your Lordship, that is why I am placing. Lordship may kindly turn to page 6 of the paper book.
No. Here I am talking about this case.
In earlier case, there was 12 hours delay.
12 hours.
12 hours. The judgment which I have cited, there was 12 hours delay.
Okay.
Now, page 4, Lordship may kindly see, that is the form of the first information report. Page 4 of paper book, Lordship.
Yes.
Serial number 3B, Lordship may kindly see.
Yes.
Information received at PS 12/7/2016 at 9 a.m. Immediately after the incident, they received the information,
Yes.
but no FIR was lodged. In 161 statements, which I have already placed before your lordships, that those were recorded in terms of the GD entry, the witnesses did not disclose the name of the accused persons. Subsequently, they inquired on their level the informant, and then he lodged the present case, naming all the accused persons. So it is clearly after for allegations. Now, I am relying on lordship that 2010-13 SCC 657.
2010.
13 SCC, volume 13.
Yes. 657.
7. Paragraph lordship 33. This is also first time deposing before the court, because in 161 they have not named the accused persons. First time they are deposing about the accused persons in the court.
Okay.
Paragraph 33, small paragraph lordship.
Yes.
In case the complainant in the FIR or the witnesses in his statement under section 161 CRPC has not disclosed certain facts but makes the prosecution case first time before the court, such version lacks credence and is liable to be discarded. That Supreme Court judgment 2008-15 SCC was relied on.
Yes.
And lastly, I am relying on lordship KIR 2023 SC, Supreme Court. KIR 23 Supreme Court, Supply 1896. I'm sorry, lordship, 1896. Here, paragraph 27 and 49 on TIT that if it is conducted in presence of IO, that cannot be accepted. On
Yes.
that aspect. Paragraph 27 and 49.
Yes.
It is a matter of great importance both for the investigating agency and for the accused.
You're reading?
And
Yes.
paragraph 27 I am reading also.
27.
Yes.
Yes. Please.
It is a matter of great importance for both the investigating agency and for the accused, and a fortiori for the proper administration of justice, that a TIP is held without avoidable and unreasonable delay after the arrest of the accused. This becomes necessary to eliminate the possibility of the accused being shown to the witnesses before the test identification period, This is a very common plea of the accused, and therefore the prosecution has to be cautious to ensure that there is no scope for making such an allegation. If, however, circumstances are beyond control and there is some delay, it cannot be said to be fatal to the prosecution, but reasons should be given as to why there was a delay. And then paragraph 49, Lordship may kindly see.
Yes.
Legality of the TIP and the presence of IO during conduct of the TIP, a three-judge bench of this court in so-and-so has held that any identification made by witnesses in a TIP in the presence of a police officer tantamount to statements made to the police officer under section 162 of CRPC. The court held the infirmities in the conduct of test identification parade would next bear scrutiny. The major flaw in the exercise here was the presence of the police during the exercise. When the identifications are held in police presence, the resultant communications tantamount to statements made by the identifiers to a police officer in course of investigation, and they fall within the ban of section 162 of the code. So here also the judicial magistrate categorically states that the IO was present when TIP was conducted. So these are my humble submissions before your lordship. So first thing, my submission is that there was delay in lodging the Azahar. The police received the information at 9 a.m. itself on the day of incident after 1 hour. But police did not examine the witnesses, lordship, and or lordship lodged an FIR because it is a cognizable case. They could have lodged.
So you tell us what is the consequence of filing the FIR after a long delay.
Lordship, my humble submission is that in the present case, already the police started their investigation on the basis of GD entry. So therefore, the FIR will be hit by section 162.
How?
Because the statements were already recorded on the basis of the GD entry that I have placed before your lordship, that
Yes,
in connection with the GD entry, only the statements were recorded. That your lordship will get page 15.
Yes, yes.
With all the witnesses were examined in terms of the GD entry prior to lodging of the FIR. Page 15.
Yes, yes.
Fulbari PR GD entry 8 of dated so-and-so. And all witnesses deposed in similar manner, so I have not read out the other statements. And the delay is fatal because lordship that in the initial stage there was no witness who could identify the accused person. Only after consultation these names were included in the FIR. And the victim, he was alive when police arrived there. Because the alleged eyewitnesses say that police arrived when the victim was lying there. So no dying declaration was recorded. That is fatal on prosecution side. And my last submission is that the TIP was conducted in presence of IO. So TIP, that identification goes. And if that goes, they have deposed the names of the accused persons first time before the court. Because the accused persons are not there, names are not there in 161. So when first time they depose before the court, their evidence cannot be accepted. That is my humble submission before your lordship.
Okay. You're done?
Lordship. Lordship.
Yes, Mr. Shila.
I'll reply next date, Your Lordship.
Mr. Azad Ahmed, Merit Counsel for the appellant, who has concluded his argument. Mr. Andy Shulai, Leonard AAG, has sought for some time to reply on behalf of the state respondent. Accordingly, as prayed for, this is matter after 1 week.
We'll make a rejoinder submission if required, Lordship.
On law points.
Yes.
Just ask them. Confirm it. Okay. Yeah. This number will come. This is not. Why is this? Just keep it. Okay.
Obliged, Lordship.
Thank you.
Obliged, Lordship.
Item number 6.
Obliged, Your Lordship. My Lord, in item number 6, I am praying for some accommodation, my Lord. If the matter can come up next week, my Lord. My friend agrees.
Then after 3 weeks, Your Lordship.
Have you
Hello.
Otherwise, why have to?